So here we are, heading into 2022. Frankly, last year was a complete washout. Basically nothing happened. We all sat home, no laws changed, and we just sat and waited for things to happen. Now we're going to have to wait and see what happens in 2022. There's a few things on the agenda. Look at homelessness, private sector tenancies, and leasehold. And lastly, quite possibly lastly, a quick mention of fixed recoverable costs. So on homelessness, at the end of 2021, the government again announced that there would be funding for local authorities to secure accommodation for street homeless people, even if they had no recourse to public funds or no housing rights. This was a welcome return of elements of the everyone in policy from 2020, but it did show that really the huge potential gains from everyone in were squandered. The government perversely maintained that everyone in had never been ended, although it had written to local authorities to say that it had ended, and there is a judicial review of that underway, which we might see more of in the near future. But clearly the opportunity to actually secure longer-term accommodation for large numbers of street homeless people was wasted, and the numbers went back up again. So hopefully this time round, although I'm not holding my breath, some lessons might have been learned, and there might be a longer-term policy to actually reduce the numbers of street homeless people beyond a temporary relief. On private sector tenancies, well, we've been waiting for the Renters Reform Bill since 2019, if not before. We are promised that at some point, hopefully this year, there will be a white paper of reforms intended to be included in the bill. Most notably, this will, of course, supposedly include the end of Section 21. There will doubtless be fresh grounds of possession, possibly modelled on those in Scotland, so for things like the landlord wanting the house back to sell or the property back to let to a member of install a member of their family. However, the lesson from Scotland seems to be that how those grounds are to be evidenced and how they're to be supported needs to be carefully considered. There's certainly been a number of cases in Scotland of landlords basically fibbing, getting possession and then simply either reletting or moving in themselves when they'd said they intended to sell. So that any fresh grounds will need careful consideration as to how they are to be evidenced and how they are to be demonstrated to the court's satisfaction. There is also supposed to be a policy of lifetime deposits, where deposits can simply be moved from one tenancy to another tenancy. Quite how that is going to work is probably going to be one of the more complicated, technically, elements of the proposed bill. Quite when we might see legislation when we are still waiting for the white paper is another matter, and time is, of course, running out for this government before a next election. And then on leasehold, there's a number of battlegrounds. Ground rent reform should pass through Parliament shortly, eliminating ground rents for all new leases, although not for existing leases. That will be a welcome step towards full-blown leasehold reform. But then there is supposed to be further reform on the cards, particularly addressing enfranchisement costs, marriage value, formation of residents' associations, and so on. Quite when that will be forthcoming, we will have to wait and see. Again, whether it comes out in this year is going to be a big question. But then, of course, the big immediate battle is going to be around the Building Safety Bill, which returns to Parliament for third reading and then on to the House of Lords shortly. And the fundamental question there is what is to happen about remediation costs for all of the unsafe buildings that have come to light since Grenfell, the many thousands of blocks with inadequate fire breaks, inflammable cladding, the wrong kind of insulation, and so on and so on and so on. As it stands, all that the Building Safety Bill does is extend the limitation period for Defective Premises Act claims to 15 years retrospectively, currently 6 years, of course. Now that might help some few, although of course the problem is there still anybody left worth suing? But it would mean lengthy and complex litigation, as indeed we're seeing with a couple of cases at the moment. Whether there will be any move beyond the current cladding fund to actually deal with the costs of remediation, and in particular to put those costs onto those who actually built the defective buildings, is something we will have to see. There are a number of amendments being proposed, both in the Commons and, one would imagine, certainly in the Lords, which would in one way or another address that, whether it's by immediate upfront government funding and then the government then pursuing the developers and the builders for funds, or the Polluters Pays amendment, which will be, I think, forthcoming in the Lords, which proposes a rather more complicated redress mechanism, but still puts the emphasis on the builders and developers paying. The government has been making noises about the liability and responsibility of builders and developers, certainly since Michael Gove became the Secretary of State. But so far that's not turned into anything concrete, it's not turned into any concrete proposals, and it's not turned into certainly any proposed amendments to the bill that have been put forward yet. Gove banning Ryden from any help to buy funds was an interesting development. It showed that the government is perhaps willing to impose penalties on those who have contributed to building issues. But so far it has been limited to that one company and has not been tied to any particular approach to redress or remediation for the affected buildings. So this one is likely to play out quite dramatically and quite shortly, I think, in the Commons and the Lords. I suspect that the proposed introduction date for the changed limitation periods of April 22 is optimistic. I suspect that the whole package might take longer than that, but we will see. And then lastly, and finally, in more ways than one potentially, is the prospect of fixed recoverable costs for civil litigation, including housing matters. Now I'm going to write on this in considerable length at some point soon, explaining exactly why it is a terrible idea. The main problem with the proposal as it stands is that the kinds of fixed costs being imposed will make it almost impossible for tenant representatives to actually run their cases without running them effectively at a loss, and this simply means people aren't going to do them. Any costs regime which in effect makes it yet harder for tenants to find representation against their landlords is not a good idea, and that looks like it's going to be the case, unless there are some serious changes to the regime or even to the entire idea of fixed recoverable costs for housing cases. It will even impact quite severely on legal aid practices, where they simply won't be able to recover more than legal aid costs, even where they're successful. And this, of course, is something which has supported legal aid practices. Whether there's going to be any reform to civil legal aid funding and with it legal aid rates, again, there's sort of vague words being bandied around, but it's not something to be counted on, and it's certainly not something that looks like it's going to happen anytime soon. This would make fixed recoverable costs a complete disaster, and I will explain why in detail. In litigation, there's a few things to look forward to, but most of the action appears to be on rent repayment orders. There is the possibility still, it's not yet been refused, of Rakusen and Jepson going to the Supreme Court, and there's some upper tribunal decisions forthcoming on what counts as a reasonable defence. Otherwise, housing litigation, it's been quiet for the last year, and I suspect is going to remain quiet for the next, but there are a few significant cases coming through. So there we are, 2022. Let's hope more happens than in 2021. Let's hope that we're not still in the same place, both metaphorically and literally, at the end of 2022.